This is Eva Lee with Banker Home Realty, and I have a very special guest here with us today. I have Sevan, who's a dear friend. He's also a teacher, and he's a trust attorney. So today we're going to be talking about some different things when it comes to real estate and trust. Sevan, I had a dear client of mine, and her mother just passed away. What happens when there's no will or trust or power of attorney in place?
That's a great question. I want to start by thanking you, Eva, for having me. I'm really excited to be here. I got some important things to talk about. But to answer the question, what happens when you don't have a trust in place? That is a very common situation. What happens is those assets, if they had any assets, would go to a court called probate court. Okay? And in my opinion, the probate system in America is the biggest scam in the world. Okay? I always advise people to avoid scams. Okay? So avoid probate court. And you do that by having a trust in place, a will in place, and the entire estate planning package. I also teach, so I always have markers in my hand. I'm used to it. If you go to CSUN, go to Matadors. I'm just going to give a quick shout out.
Lovely.
Here are three scenarios, and this is my attempt to draw, okay? Now, here's scenario number one for those in real estate. I had a client call me, and this happens quite frequently. They had a house, husband and wife, David and we'll just say Angela. The title to the house was only in the husband's name, David. Unfortunately, David passed away, okay? Sorry, David. I'm going to put an X through you, okay? David passed away, and after the surviving spouse grieved and mourned, she decided to sell the house because she didn't want any more memories of him. She had a lot of memories in the house, so she wanted to move on. She came to sell the house, and hopefully they would have retained Eva to sell the house. The realtor told her, you can't sell the house, and so did the title company. Well, why not? She was devastated. The reason is your name on the title? That was the most simple question they asked, is how can you sell a house if your name is not on it?
Sure.
Can I come sell your house? No, my name is not on your house. Well, I hope it is. So because her name is not on it, they did not have a trust in place. And I'll explain how a trust would have solved their problem. Because they didn't have a trust in place, what happens is this house now has to go through a court system called probate. And the probate judge has to determine whether you are the wife, and if so, that's when your name gets placed on title. Now, it is true that in California, it's community property. Yes, this is her house, 100%. No one's disputing that. But before you can sell it, do anything with it, refinance against it, she needs to get her name onto this title. So because they didn't have a trust, probate is open, and you prove to the probate judge who you are. My name is Angela, here's my marriage certificate, here's the death certificate, here's some pictures of us, and the probate judge says, now I believe you, and then signs the document, and now Angela's name gets placed on title, and that's when she could sell it. Do you know how much that cost? She probably spent $20,000 in legal fees and in court fees to do that, and probably 1 year of delay. Okay?
Oh my God.
What a waste, what a scam. Okay? So now, had they had a trust, the house would be in a trust, and both David and Angela would be in control of the trust. And I'll explain what trusts are. And that would have avoided the whole probate system.
Mm-hmm.
So that's one scenario.
Okay.
Here is scenario number two. I had a client call me. His mom had passed away many years ago, and the bank account was in his dad's name. There was about, let's say, $20,000. We'll say Chase Bank. It was not Chase Bank, but we'll just say Chase Bank. His dad died, and he went to the bank and says, here's my dad's death certificate. You know who I am. Can I take out the money, so I could give it to myself and my siblings? Same thing. What do you think the Chase bank teller told him? Is your name on this bank account? No, it's not. Well, then how in the world am I supposed to give you this $20,000? Simple idea. So now, because the dad did not have a trust, to name his son as the successor trustee, which I'll explain, this bank account would be subject to probate court, for the probate court to approve the son to take this money out. Again, expensive, timely, and a scam. Lastly, I'm gonna call this person Amy. She worked as a teacher for the California state system, and she had a very hefty retirement account over the years, about $76,000. She had no immediate family, and this happens. If you're an only child, parents have passed away, you don't talk to your cousins, and you have no nephews or nieces. So she had no family. Under our, I guess, probate or trust system, California law has a specific way of assets are given to your family members or heirs. She didn't have any family, nobody showed up. So if there is no family that shows up and says, oh, she was my mom, whatever, what happens is the money will, what's called escheat. It's a strange word. The money will escheat to the state. This means her $76,000 went to Governor Newsom in California. So the money goes to the state. Now, had she had a trust in place, her family members knew she was a very, very big animal lover. I'm sure if Amy was alive, she would say, I don't want Governor Newsom and the state to get my retirement money. I would love it to be donated to the Pasadena Animal Humane Society. I'm pretty sure that's what she would have wanted. She didn't have it, so the money is cheap to the state, $76,000 is gone. So these are three separate scenarios. Had these clients had a trust in place, these problems would be solved.
Oh, wow. So why don't people have a trust in place?
So I believe individuals don't have an estate plan or a trust or a will in place is mostly because they believe it's for wealthy people. They believe it's not for them, okay? And I think it's kind of with a lack of understanding of what it does, okay?
Okay.
So, and people think it's costly, it's not for me, I don't need it.
Sure.
But these individuals also thought they didn't need it, okay? And it's very important, so that's why.
Okay, so is a trust or estate plan for everyone?
No, that's also a great question. Not everybody needs a will or a trust, okay? So under California law, you can have, and this is a funny number, you can have about $160,000 of assets that will not be subject to probate court. I'll give you a classic example. My own grandmother, I love her, 97 years old, God bless her.
Aww.
She doesn't own a house, she doesn't have much assets, she doesn't have a car, okay? She probably has some money in the bank account. She doesn't need a trust, okay? Because that asset she had, let's say she has $5,000 in the bank account, okay? That money can avoid probate and just go to her kids, okay? Because it is under that limit. We're talking about assets over 166. If you have a house, I guarantee you, you're over that limit. So not everybody needs it. But perhaps my grandma would want it. Maybe she doesn't want to give it to all her kids. Maybe she wants to kind of identify, I want my favorite grandson, me, to get this art on the wall, whatever. Now, if she doesn't have it, we among family members will decide what she wanted. Yeah.
Okay.
So
that's wonderful. Okay, so what you're telling me is that if someone passes away, they will go to probate, and that's going to cost a lot of money, and it's going to cost a lot of time, and of course a lot of sorrow and energy. So what should people do?
I recommend to think about creating an estate plan, okay? What people think is a estate plan is just a trust. That is not correct, okay? The estate plan is composed of many different parts, okay? And I'm gonna flip this board around, okay? And like magic, it's already written on. This is what a estate plan is composed of. Most people just want to do the trust. I don't think that's a good benefit, okay? I think you need to have the whole package. A estate plan is composed of a trust, a will, guardianship for your children if they're under 18, a power of attorney document, and your medical directive. So this is what's composed of the estate plan. most individuals will charge anywhere between $3,000 to $4,000. If you go to my website, for the entire estate plan package, I charge $1,950, and this includes the notary fees, this includes the county recorder's fees, this is all inclusive. People ask me why are my fees less than the others? It's because I wrote my own software, essentially, my Word doc software, so I don't have to pay expensive licensing fees, so I pass that saving on to the client. And it shouldn't be that costly, okay? This includes one home. If you have additional properties, we charge $400 to put that other properties into the trust. The most important one is a trust. What is a trust? It's no different than having a suitcase. So inside the suitcase, you can put all of your assets. We put your home inside your suitcase. You put your bank accounts inside, your clothes, your jewelry, everything goes in the suitcase.
Okay.
While you are alive, so this box represents Eva's suitcase. We give it a name, okay? We give it a name. This is the Eva Trust. We can call it the Eva Living Trust, Eva Revocable Trust. I'll explain what those are. But we give it a name. This is Eva's box. Let's say Eva has a house, okay? Mm-hmm. This house will come in here, her bank accounts, okay? So let's say she has a business or LLC, everything will come in this suitcase. While you are alive, you are in control of your suitcase. This is yours. You could cancel it, you could change it, whatever you want. Let's say, God forbid, many years from now, you pass away. You then want to appoint people to be in charge of this box. This is called you say, my successor trustee, the person that's gonna take over management of this box. Let's say you want to name your cousin, we're just gonna give him a name. I choose Andy. Andy's job is, once Eva passes away, the box closes, Andy steps in and says, let me see what Eva wanted to do with the contents of this box. What did she want to do with LLC? Maybe she wants to sell it, whatever, okay? So then Eva will also identify beneficiaries, okay? So let's say, she has kids, we'll say Tim and Tina. So Andy says Eva wanted the house to be given to Tim when he turned 30 years old. And for Tina to get the business, which is also worth almost the house or whatever. So all Andy does is distribute the assets inside Eva's suitcase to the children, okay? That's all the trust is, okay? So people have complicated this for many reasons. Now, going back to the three scenarios on this side of the board, had that husband and wife created a joint trust, the house would be in there. So once husband unexpectedly passed away, the wife is still in control of the suitcase, which means she's in control of the house. She could say, I'm ready to sell it. Had they had this, it would not go through probate and spend $20,000, okay? Same thing with the Chase bank account. Had the dad been in here, he would name the son as a successor trustee, take the bank account, put it into your own pocket. So this is what a trust does. Very briefly, what a will does, and we call this a pour-over will. Okay, so it's a pour-over will. A will, combined with a guardianship, a will controls your assets that are outside of this box. Let's say you bought a car and it's not in your trust. You got it many years later. What happens to this car? What the will say is any assets I have in the future, or if it's not in the trust, my wishes are to give it to the trust. You're gifting it to your trust. The reason why it's called a pour-over, imagine like a pitcher with a cup. The cup is the trust. The pitcher just basically pours your assets that are not in the trust into the trust. And whatever your trust instructions are, that's where the car will go. So it kind of captures other assets. In the future, you want to make sure you take title in the name of your trust. So if you buy a house 5 years from now, you don't buy it in your name, Eva Lee. You buy it as Eva Lee as the trustee of the Eva Lee Trust. That's what it'll say on title. So you want to buy things in the name of the trust. That's how you get it into the trust.
Oh, so you should create a trust before purchasing a house if you
Right.
haven't purchased the house yet.
Right.
Okay, got it.
So people say, if I just have a will, is that enough? What people don't understand is a will is public, a trust is private. If you just have a will that says, I want everything to go to Eva, okay? This will, my will, still needs to go through probate court. Probate has to be open. Eva will take my will, give it to the probate judge, and it goes on the public court's docket. They give notice to all of my beneficiaries saying Gorginian has passed away and this was his will. And everyone watching can log in and you can see my will.
Oh my God.
I feel uncomfortable for the public and for my snoopy family members to go look to see what did I have, who did I give it to, how much did I give to her. So a will is public. That's why a trust remains private. A trust does not go to probate court. This remains private. And going back to this whole pour-over idea is whatever you don't have, the will just say we are pouring it over and giving it to the trust, so it remains private.
So, Sevan, do you see any trouble or problems with trusts?
Yes, a lot of things can come up with trust that can give a problem. The most common one is not putting your stuff inside your suitcase. This is called funding your trust. Just like you would fund a loan. Think about funding a trust. You're putting your stuff inside the suitcase. It does no good to pay me $19.50 for me to create your entire estate plan in your trust, and you create your suitcase, but you don't put anything in it. You just completely wasted time, okay? So you have to put your stuff in here. We will help you put your house in here, and we give you instructions on how to put your business in the trust, and all your other assets. That actually reminds me that there's a big question that's always asked, is if I have a property, let's say I have another property, and this property is in the name of an LLC, do I need to change this title into the name of the trust? No, you don't. That property, the title can remain in the LLC. So what comes in your trust is your shares. You assign, we do a general assignment that says, Eva, as the 100% membership holder of this LLC, I assign it to my trust. So that way your membership interest comes in the trust. And if your membership interest is in this trust, that means Andy can control those shares, which means he can control that house. So you don't have to change title to a property that's an LLC. But to answer your question, what are some problems I see is in the last 2 or 3 years, because of the market, I've seen a lot of people refinance their loans. A lender, a bank or any lender, will not give a loan to the trust. Yes, this is Eva's suitcase and she's in charge, but they will not give it to her while the property is in here. What they're gonna say is, Eva, we need you to take the property out of the trust. Now the house is under Eva Lee only. They'll give you the loan, and then after you get the loan, then you wanna quick claim it, do a trust transfer deed, and put it back into the box. For my realtor friends and my loan agent friends out there, please make sure that title company transfers it back into the trust. You don't want to wait 20 years once the person passes away for the beneficiaries to find out that you didn't retitle it into the trust, because then the house remained out of the trust, which would be subject to probate. Please make sure you retitle it back into the trust. With respect to guardianship, this is for your children, okay? If they're under 18, the guardianship documents will say, I want to choose my older sibling to take care of Tim and Tina. And you say, you can use the trust assets to raise my children. If you don't have guardianship documents, the probate judge will determine for you, They'll say, your older sister is good enough. What if you don't get along with your older sister? And what if your older sister were to kind of, you don't trust her, she's gonna steal those assets by the time your kids become of age. So guardianship, you stay in control. I want my brother to raise them, here in Burbank or something. Mm-hmm. That's what a guardianship does. The power of attorney forms says, if I am incapacitated, God forbid I'm in a coma, or if I'm not available, I'm in surgery for whatever. The power of attorney form, it kicks in, you don't have to die, okay? You can still be living. Let's say I have to go into surgery. The power of attorney form says, I appoint Eva to be my agent for financial purposes. So at that time, if the mortgage payment needs to be made, she can open up my checkbook and sign it and put as agent of power of attorney. So she can write checks for me. She could go to my tenants and say, give me the rent. They're gonna say, Eva, who are you? I'm the agent. You know, Gorginian is not available, but you have to give me a check. Here's a copy of the power of attorney. So you can make financial decisions for me.
And anyone can be that?
Yes. Most people select the successor trustee, the person in charge of their box after they leave. They name the successor trustee, Andy, to also be the agent. It's the same person. You don't have to name it the same person, but most people do.
Okay.
Lastly, the medical directive is with respect to your health and your wishes, okay? In the medical directive, there's three main components. Number one, there's a section talking about, do you want to be kept alive artificially? Most people think, you know, yes, try to save me. That's not what it means. The artificial part means that if the doctors determine that you are never getting better, you will always be in a coma, what are your wishes? Do you want to be kept alive on tubes and on artificial support? Most people select no. If you don't have that, your family members would have to decide, and I hope they get along. I hope Tim and Tina can get along about what mom wanted. So you could say, I don't want to be kept alive, and they'll cut the cord. The other component about medical directive is what's called the do not resuscitate portion. If you show up to the hospital, God forbid you don't have a heartbeat or you're not breathing, do you want to be resuscitated? Most people say yes, try to resuscitate me. If you say no, they're not going to try to resuscitate you. Some people have a different beliefs, different religions, saying if I'm gone, I'm gone. Okay. Other people say no, please try. Lastly, do you want to be buried or do you want to be cremated? Is there any special wishes? So again, if you don't have a medical directive, imagine, you know, in the last few years because of COVID, people have been in the hospital, the person is unconscious and they're on tubes. The kids are in the hospital room talking about what should we do with dad, you know? The doctor comes in and says, who has the medical directive? Oh, we didn't do it. The doctor says, okay, well then I decide. And I think your dad is not gonna get better. We're not gonna try to resuscitate him. Thank you, goodbye.
Oh, wow.
So that's what a medical directive does. Again, the whole point of all this is that you stay in control. So that's pretty much it. And if you go to my website, you'll see everything explained.
You are offering all of these 5 things for just $19.50?
That's correct. So all of it for $19.50. This is for one home, which is what most people have. This also includes the notary fees and the counter recorded fees, okay? So when people come to me, I'm not gonna say, give me this, plus you gotta pay the notary. No, this is all inclusive, and we are pretty efficient.
Thank you so much, Sevan. And if you guys have any questions, please let us know, because he can answer all questions you guys have about trust and will, even bankruptcy. So thank you so much for being here with us, and thank you.
Thank you so much. Thank you, everybody.